Hi, it's Madison Kiza, and today we're going to be discussing customary marriages in the context of financial planning or estate planning. So I thought I'd do this video because sometimes you meet clients where you need to, or they ask you to help assist them with their estate planning. And as you go through the process of asking questions and listen to the client, you gather that they might have been perhaps married in terms of customary law in the past. As the conversation goes on, he'll tell you, but we're no longer married. I left her as an example, and I've moved on to marry somebody else in the future. Now, the question then becomes, or something to be cautious about, is number one, if you've married later on, is that even valid? Is that union or that marriage even valid? Because you were married previously, and if you were married previously, was there proper dissolution of that marriage? What is the situation? Because the problem with this, with those questions not being answered, it puts the financial advisor or person engaging in estate planning for their client in a predicament, because they don't know how to draft your will. They don't know what your assets are and what your assets or which assets are not yours. We haven't even gone to questions around if, for example, say they are married. Are they married in community of property or ANC with their accrual or without the accrual system? There's many other questions to be asked in terms of finding out the status of these marriage. So the important thing is, as the first step is to understand if the client is married specifically for this video in terms of customary law. How do we determine if that marriage is in fact in existence before we even determine the question of how they share the community, for example, community of property? So this is just going to be a guide in terms of just a general framework of what the different provisions are related to customary marriages. Now remember, this is not looking at civil marriages, like I mentioned earlier on, community of property, ANC with accrual. It's not looking at civil union marriages. One of the highlights being, for example, that same-sex married couples can get married. It's not looking at those particular regimes. It's primarily looking at customary marriages in terms of customs and traditions of the indigenous people of South Africa. So that's a clear distinction that must be made. Now, because of our unique situation as South Africa, in terms of applying the law with regard to customary marriages, there's a lot of things that you got to think about. And I thought the best way is just to perhaps build a number line, starting from the introduction or when the Recognition of Customary Marriages Act came into effect in year 2000, and we'll work it out backwards in terms of our number line, and then by doing that, highlight certain ways that you can start thinking about a customary marriage situation, then see how the courts apply the rules. Obviously, cases differ, as I'll mention one or two cases to illustrate the points, but at least you have a thinking around what is actually applicable and what is not applicable when engaging in that sort of discussion. So for our discussion, the RCMA basically requires three main things. Firstly, that both parties are over 18 years old. In other words, they're majors, both the groom and the bride. That both parties consent to the marriage to be married in terms of customary law. And then lastly, the marriage must be negotiated and entered into or celebrated in accordance with customary law. Now, generally speaking, you'll see that the first two are pretty straightforward to deal with. And then the third one is the one where the contentious issues start coming in, and we'll discuss one or two cases and see how the courts have applied the law in terms of determining whether the customary marriage even exists or not. And then at this stage, it's worth mentioning as we go back in time that we've had the interim constitution 1993, which managed the whole thing for the final constitution to come into effect in 1996. Now, as we go through this discussion, you'll see how pertinently important the Constitution plays a role in managing this whole discussion around or determining whether a customary marriage exists or not. And first two sections I want to just highlight of the Constitution is Section 39(2) and Section 211(3) of the Constitution. Now, basically, without going into detail in it, the first one, Section 39(2), talks about developing the customary law as the court interprets it and apply it. And then the second one is that whatever laws are applicable anyway in the state are always subject to the Constitution. So as much as we go through the rules, for example, based on the Recognition of Customary Marriages Act, the RCMA, we always have to be mindful of the Constitution, because it's always the guiding supreme law in our country. And another one worth mentioning, and we'll do a case on it later on, is the Bill of Rights within the Constitution, where Section 10 talks about the right to dignity. So you'll see how that plays out again later on. Now, going even further back into time, we had the Zulu codes, and there were different types of codes, but basically they were around the period 1985 to 1987. I did not go into detail with them because that's not the focus of our conversation. But however, the important thing about this number line is straight away, obviously, if you're dealing with somebody married in, say, 1989, and they are Zulu within the KZN region, KwaZulu-Natal, then straight away you know which kind of laws will apply for that particular individual. So this number line is very important from at least identifying for your client what kind of laws will apply. So if you take another example, if somebody was married in year 2002, and they've chosen to get married in terms of customary law, straight away you will know that the RCMA will apply in those conditions and not the other laws. However, the Constitution, as we'll see later on, will always be around and will always be applicable. So now we know that we have these, we have the codes, we have the Constitution, we have the Recognition of Customary Marriages Act, in terms of guiding us in figuring out what is happening. But at the end of the day, how do we prove, because remember, these are court cases that we're using as a guide, how do we prove to a court that in fact our person was married in terms of customary law? So for marriages after the Recognition of Customary Marriages Act came into being, it's easy because it allows you to register the marriage. In fact, for marriages before that too, you can also approach Home Affairs and register the marriage. It allows for that. However, what happens to the marriages that were not registered in terms of the Recognition of Customary Marriages Act, because they happened prior to the Act, or just simply that they were not married, that they were not registered even after the Act came into being, it becomes difficult to prove their existence of those marriages. And just as a quick note, if there's a failure to register a customary marriage which happened before 2000, it doesn't mean that the marriage is not valid. It just means that, for example, should a court action come into effect, it would be more difficult to prove. It is so far easier to just register the marriage. So like I mentioned, now, when it comes to death or divorce, or just planning, how do you even prove that that marriage actually exists? And in comes the law of evidence. So there's two sections that I just want to touch on, and then the first one is Section 1.1, which basically recognizes the official law approach, and then Section 1.2, which basically recognizes the living law approach. Now, without going into details for our purposes, it's just basically saying the official law is if something is written, if they say it is written that in terms of customary law, these are the requirements, then it's straightforward, and then the marriage can be recognized, or at least easily ascertainable. Things like, for example, the settlement of lobolo. So those things are much more defined. Therefore, that becomes official law, and if a requirement in terms of that official law hasn't been met, for example, lobola, then there is no marriage. And then the second one is a bit more different in the sense that it goes a bit further. it recognizes that, yes, there is official law. However, that the living people, the African indigenous people that are currently living have tweaked certain things because things have changed and have modified certain practices. And therefore, through, for example, getting evidence through witnesses, you can therefore figure out what the new custom is in terms of a particular matter, such as, for example, payment of lobola. You'll remember, for example, when you look at lobola back in the day, if you had to look at official law, it might say, well, there were cows that were delivered in terms of payment of lobola. And if you had to apply that purely, then a lot of marriages would be null and void. However, when you look at the living law approach, it might say, reach a conclusion where it says, well, because of the customs and things have changed for various reasons, now lobola is acceptable in, for example, monetary terms. Now, just to illustrate how the courts have taken the official law in interpreting whether a marriage exists or not. And it's a case of Motswatwa versus Ororo, where the deceased was married to the applicant. Basically, they were living as lovers since 2005, and the deceased passed away in 2009. However, between that period, the deceased had introduced his future wife to his parents. A lobola was agreed upon, and that was settled, and they carried on living. However, when the deceased passed away, he had passed away without a will. Now, naturally, what happens is the law of interstate succession comes in, which means then the house that he was living in, that he owned, must actually devolve to his parents that were still alive. And all of a sudden, the surviving spouse basically couldn't register the marriage because they were married in terms of customary law. They couldn't register the marriage posthumously with Home Affairs. They were blocked by basically the parents of the deceased. Now that leaves the deceased in a predicament, because now they would have thought that they are married and living comfortably, and that upon his death that she will inherit something so she can continue living. But in terms of this case, it was not to be so, because they had failed the simple requirement of the bride had not been formally delivered to the groom's family. So in arriving at his conclusion, Judge Matlapeng, concluding that no valid marriage existed, one of the crucial elements of a customary marriage is the handing over of the bride by her family to her new family, namely that of the groom. Until the bride has been formally and officially handed over to the groom's people, there can be no valid customary marriage. So therefore, in this case, the marriage was found not to have existed. Now, in a different case where the formal approach wasn't used, but rather instead of the official law approach being used, but rather the living law approach being used, was the case of Mabena versus Letwalo. Basically, in this case, ultimately the contention was whether the marriage existed or not, based on the fact that the lobola that was paid should actually be received by the male guardians of the groom. Now, in this case, the lobola was paid to the mother of the bride. And now they were contesting whether that should have been actually allowed to have been recognized as lobola have been satisfied or not. However, the court, in arriving at a conclusion, realized that yes, while there is the official law approach where traditionally lobola is negotiated between the males of the guardians of the two bride and groom. However, in practice, there has been instances where females have actually been negotiating lobola and accepting the payment of such lobola. So therefore, in this case, the judge found that the marriage was valid, and it was not negated by the fact that the marriage was actually negotiated and paid by the mother of the bride. So what's interesting about this case is, in fact, it was actually decided, as you can see, in 1998, before the whole equality thing came in, which we'll see later on in terms of the Recognition of Marriages Act. But it did not just look at the official law stance, and it actually developed the law in a sense, because now women were actually allowed to negotiate and receive lobola just by looking at the current customs and culture of the indigenous people. So in the judgment of Fanti versus Bodo, which is a constitutional court judgment, where you reference the Mabena case, which we were just talking about, Judge Dodo observed that if courts do not observe the role played by women in society, then that would include failure on their part to participate in the development of customary law. So that was quite a big change, instead of just focusing on the official rules, but rather looking at how society has changed now and letting women participate, which is something that's guaranteed by the Constitution anyway. So, through the law of evidence, you've seen that how courts can apply the official law approach, and that kind of tends to lead to non-validation of marriages, because it's very sort of fixed. And if you don't qualify for that, the marriage seems to be null and void, basically. And then the second approach was the living law approach. Now, above all of these things, there is still the Constitution that we spoke about, and we'll make an example of a judgment where the constitutional development approach started creeping in and started to reach perhaps as different conclusions to just by applying either or of the official law approach or the living law approach. So there's an interesting case in the Constitutional Court of Mayelane versus Ngwenyama. Basically, the facts of the case, just in a nutshell for our purposes, was that the deceased was initially married in 1984 in terms of customary law, and things happened, they didn't get along, and then later on, he married somebody else in 2008, again in terms of customary law. Now, when he later on died in 2009, the issue was, well, who was going to be recognized as the wife of the deceased, because they were going to inherit interstate, because they died without a will. Now, the court, the constitutional courts, they absolutely looked at the official law approach, what needs to be done, was lobola paid, and so on and so forth. And then they also looked at the living law approach, what the community thinks. They called in witnesses and so on. But where it found the second marriage to be invalid, the one that occurred in 2008, was because the first wife was not had not consented to him taking on a second wife. Now, what is interesting in this case is the court was looking at concept of dignity, which is in Section 10 of the Constitution under the Bill of Rights, and there in terms of Section 10, everyone has an inherent right to dignity. So by inherent, the actions of your husband deciding willy-nilly, basically to take on a different spouse and coming back home and saying, "Hey, here's a new wife." That would infringe on the current wife's right to inherent dignity that she has. I mean, a marriage contract is quite a personal contract. So the court said, although we recognize that from an official perspective, the case here involves Tsonga people, we recognize that the rule is that the husband merely has to inform the first wife of his intention to marry, to take on a second wife. But the court upgraded that it should be read as basically that the first wife must consent to him taking on the second wife. Otherwise, he infringes on her, the first wife's rights to dignity. So now you start to see a difference in approach taken by the court, where they number one, acknowledge that there is the sort of the formal law that exists, and yes, we've called in witnesses to try and determine what the living law arrangement is. But however, as a constitutional court, we are bound to protect these rights enshrined in the Constitution, principles of equality and dignity. And you'll see that when I talk about equality here, the court in that case was relying on the equality clause within the Constitution. But then later on, and you see just in a further slide or two, how the Recognition of Customary Marriages Act itself has introduced this notion of equality. So you'll notice that from a constitutional perspective, the equality of spouses approach has also come in, where literally within the Act itself, the RCMA Section 6, equality of the status or the right to contract and those kind of things is guaranteed to both husband and wife. In the past, a wife, for example, was treated like a minor, basically. If she wanted to enter into a contract, she didn't consent of the husband, as an example. So the equality has been dealt with within the RCMA. And of course, the Constitution, like I mentioned earlier on. So obviously, we just flew through the whole framework of how customary marriages are managed. One would definitely have to consult. I think with the different approaches that I showed you, it's not very cast in stone and very dependent on the facts of each particular case, as I showed you, for example, through the number line. But ultimately, you can rest assured that if there is even a clear principle of a formal way of doing things that is in contradiction or not in the spirit of the Constitution, that would be shot down by our courts. I think that's one thing we can certainly take away from this. But in terms of coming back and doing financial planning, it makes it very difficult for a financial advisor to deal with a person who does not know his marital status for sure, because he doesn't know how to draft the will. He doesn't know whether trust can be created, whether certain funds can be moved, who owns these funds, and so on and so forth. So it seems like a headache up front, but it is good to consult with perhaps an attorney to try and figure out where you stand as a client. If you've been married in terms of customary law, just so that it just makes it so much easier to do financial planning going forward. So that's it on customary marriage in terms of just a high level overview. If you're interested in further reading some of the articles that I used, one of them, I'll attach it on the description below, was by Professor Liam Mwambwene, which was entitled "The Essence Vindicated: Court and Customary Marriages in South Africa." I'll put that on the description below. So yeah, thank you for the video. I hope you enjoyed it. Yeah, I'll see you next time. Thanks.